We are going to move on to the presentation session. And I would like to introduce the moderator of the presentation and discussion session from Sungkyunkwan University, Professor Kim Sung-don. Thank you for joining us. 김성돈 교수님, 시작해 주시면 되겠습니다.
Professor Kim, please start. Thank you very much, Professor Zatsvka, for your keynote speech. Now we will go to the presentation session. I am Professor Kim Sung-don from Sungkyunkwan University, and I'll be moderating for this session. In this presentation session, we have two parts. The first part consists of three presenters who will talk about climate criminal law or environmental criminal law and green criminal law, the trends and forecasts of these laws. And then we will look at the second part, how ecocide can become a new punishable crime under the international law. And we will have one presenter for that subject. We will give 15 minutes each to the speakers, and then we will go to the discussion time, and 5 minutes will be given to each discussant. Then that will give us about 20 minutes for a wrap-up discussion. It's my role to keep everything proceeding as scheduled. After I introduce the presenters, I'd like to ask the presenters to go straight into their presentation. The first presentation will be made by Dr. Jee-young Yun, a senior fellow at KICJ. Dr. Yun started working at KICJ from 2010, which is the year right after he received his doctorate degree. He also lectures at universities and works as advisors to many legal and administrative organizations. And he started a project on climate change and related criminal law. He conducted many projects on this subject, and in 2020 he received a reward from the Minister of Environment in recognition of this important work. Dr. Yun, please go ahead. Yes, good afternoon. My name is Jee-young Yun from the Korean Institute of Criminology and Justice. I have been given about 15 to 20 minutes, and I will try my best to keep the time. In 2016, at the Academy Awards ceremony, Leonardo Dicaprio received his first Oscar award, and he said at this time that climate change is real, and it is happening right now, because at that time, 2016 was the hottest year recorded in history. He said in his acceptance speech that climate change is real, that it's happening right now. And this is what he said. We all are used to taking nature as something granted, but his speech resonated through many people's heart. For 4.6 billion years, the climate condition of the Earth constantly changed, but after industrialization, the temperature rose artificially, and climate change took place in a short amount of time, not giving enough time to people to adjust to that. and this gave rise to serious concerns. To respond to such climate change, Korea established many laws, including the Framework Act on Low Carbon and Green Growth. In March 13th in 2020, 19 teenagers, members of the Youth for Climate Action, filed constitutional complaints for reasons that their right to life and environmental right were threatened due to the government's past policies on the reduction of greenhouse gas emissions. This case is still pending in Korea. And in Germany, on April 29th, there was a partial unconstitutional ruling on the Federal Climate Protection Act. It stipulated that the greenhouse gas emissions only went up until 2030, and reduction target after that is not clear. So therefore, it infringes the basic rights of the future generation. The Criminal Law Society of Korea recently looked at the applicability of domestic law for criminal crime, and papers were published on this. The principle of subsidiarity or ultima ratio in criminal law was emphasized, and they found that it was difficult to find a difference from existing response to environmental crimes. In the international community, there were discussions on ecocide and the possibility of adding that as one of the international crime punishable by international law. Professor Zatsuka talked about this. Ecocide right now means that it's an illegal act that has been committed, although knowingly the actor knows that it will cause long-term harm. Personally, I believe that we need to have this legislated that defines this as a crime. Another country that I'm very interested in is France. In 2016, France established a law to reduce food waste, and they forbid supermarkets to throw out unsold food. In the past, they used to pour bleaches or water on food which was not sold so that those could not be sold. But now with the new legislation, food that are close to expiring need to be donated to charities or food banks, and they're not allowed to simply destroy and throw out the food. Especially for large supermarkets, they are required to sign a contract with charity organizations for donation. And in the case of violation, they are subject to 2 years of imprisonment or fine up to 75,000 euro. This legislation was passed unanimously, and it was a breakthrough action to reduce food waste. France also introduced the Consumer Act 2016, which imposed criminal penalties on planned obsolescence. For example, you might remember in 2016, Apple wanted people to buy their new mobile phone. So they were suspected of making sure that the functions of the old model declined. So in order to make sure, and Apple admitted to that, they said that as the battery life expired, the iOS was designed to function less effectively. After they admitted this, they promised to support battery replacement. Also in France, the ink in the printers were designed to stop working when the level of ink dropped to 20%. So an investigation was made on the printer manufacturers, and they believe that this was a type of fraud deceiving consumers. And it attracted much attention due to sustainability of products. Germany was quite critical of the discussions on the French laws. In the seminar that took place in Munich University in February, these sort of topics were discussed. Among the professors that were there, They had written many papers, and I looked these up. Professor Wolfgang said that the current criminal law is not adequate for protecting people. Professor Elisa Hoven said that in terms of manipulating product life cycle, it's important to notify consumers of the average life cycle. And so therefore, the legislation of France should be referred to by Europe so that they can make more sustainable products. As you can see, climate change is a crisis, but does that mean that criminal law cannot play any role regarding climate change? I think it is now that we start serious discussions on that. First of all, violation has indirect impact, and the causality is difficult to prove. Environmental criminal acts tends to also change from crime of result to crime constituted by endangerment nowadays. As technology and science develops, is it possible to prove causality? TMS is a telemonitoring system, and we also have IBM's Green Horizons Initiative program, and these are some examples. As you can see, we have a remote surveillance system on chimneys. In the past, the investigators would carry very heavy equipment to measure the emissions emitted from the chimney, and they had to collect the samples for about 30 minutes. That made that they were very slow to come to the site, and it wasn't easy to detect any harmful acts. But nowadays, we have new facilities that continuously collects data and transmits the data real time. Another thing that I'd like to talk about is IBM's Green Horizons initiative. From 2015, IBM created an atmospheric map that allowed the program to predict the environment over Beijing 72 hours beforehand. They looked at the pattern that pollutants disseminated, and sometimes warnings are issued. Along with atmospheric data, sometimes the pollutant source can be exactly located by this program. AI is used to identify the source of pollution. If this is possible, then the causality problem can be also resolved to a certain degree. Also, right now, the current laws focus on legal interests of people living now. But intergenerational justice also becomes an issue. This term was used in the impartial and constitutional decision made by the German court. But whether that can be established as a principle still remains to be seen. Right now, all the criminal laws are centered on people, but now this should be expanded so that the ecosystem, including animals, are also subject of protection by criminal law, because now animals are becoming subject of protection on itself. That means that this transition of expanding the protective scope to include ecosystem is already happening. The principle of ultima ratio, or the last resort, and the principle of subsidiarity is also something that we need to think about, because it becomes a limitation. Because there are differences in view regarding how serious the problem is. And criminal law should stand by until it is proving that everything else is useless. I disagree with this view. When the Improper Solicitation and Graft Act was introduced in 2015, there was criticism that the act violated the principle of subsidiarity of criminal law. But now there's a positive view on this legislation because it changed the widespread culture of improper solicitation in Korea. And the doomsday clock is 1 minute to midnight and still ticking, so it's time to consider the function and roles of criminal law. As the existence of human beings continues to generate environmental pollution, we are all guilty because we use cars to move around, we use the heating system, and we all contribute to CO2 emissions. But not all of these are crimes. Where criminal law has to get involved and not has to be distinguished. Corporates who seek profit sometimes destroy the environment through criminal acts, and when it is done knowingly, it should be punished. Regarding the applicability of criminal law in Korea, the argument was that it was difficult to apply the domestic law to transnational crimes, and that the individual country's criminal law should not serve as the sheriff or watchman for global crimes. However, for transnational environmental crimes, we need to introduce globalism. If ecocide is defined as international crime, the individual countries must do this. To overcome climate crisis, individual countries should play an active role as a sheriff or watchman. A while ago, at the Conference of Parties 26, the Ministry of Foreign Affairs of Tuvalu delivered a speech and attracted much attention. Tuvalu consists of 9 islands in the Pacific Ocean, and they're only 3 meters above sea. As sea levels rose, 2 islands have already submerged underwater, and so this country itself is threatened.
Public mobility must come to the forefront. We must take bold alternative action today to secure tomorrow.
People's lives are being threatened in many places throughout the world, and we need to ask whether we can have criminal law act some role.
Thank you very much, Dr. Yun. You have left us with a more optimistic conclusion, and that we need the intervention of a constructive criminal code to intervene in environmental matters. As the second speaker, we have Professor Hirokazu Kawaguchi, who is teaching criminal law at Meiji University Department of Law in 1984. He has attended Kansai University and received his LLM in 1996, went to Germany's Freiburg University where he got his PhD, and from 2018 he has taught criminal law at Meiji University. In 1990, for 2 years, we studied together side by side at Freiburg University, and it's been 20 years since we last met. At the time, the topic was organ transplantation. It was a leading research topic, and now you're leading the pack with a very pioneering topic of climate change. Please begin. Thank you very much. I am Kawaguchi, and it's a pleasure to see you in such a long while. I hope that we'll be able to see each other more often. I would like to thank you very much for inviting me to this forum. My thanks go to the organizers. In my presentation, I would like to talk about the climate change, the climate criminal law. I would like to mention specifically precautionary principle and the cumulative offenses. And I would like to discuss these two principles. First of all, I'd like to talk about the significance of precautionary principle. In dealing with global warming in environmental law, the precautionary principle is at play. It is emphasized. And whether to apply precautionary principle to the environmental criminal law or not will be discussed. And I took this from the EU's think tank website. And so the decision maker considers the environment and the impact to human health. Even if the scientific evidence is uncertain, when the stakes are high, the precautionary principle is to be adopted. That is the direction of the EU policy. But in Japan, in the traditional sense of criminal law, they have precautions. And when we look at the Japanese legislations, in 1998, the Global Warming Countermeasures Promotion Act was adopted, but there is no direct punishment on the act of emitting greenhouse gases. And as you can see, from this paper, the rise in the average greenhouse gas concentration in the atmosphere that could be considered in the Japanese legislative framework. And so the criminal countermeasures could be reviewed, and that is what is required of the climate criminal law. And what is gaining attention in Japan is the concept about cumulative offenses. And I would like to talk about its relation to climate crimes. Let us now first look at the discourse taking place in Germany. The concept of climate criminal law and cumulative offense. As we look at the theoretical background, what is most often discussed is this cumulative offense theory proposed by Dr. Lothar Kuhlen. It is referred to in Article 324 of the German Penal Code, and it deals with the success of criminal water pollution. If the water is polluted, if the water quality is deteriorated, then that offender is subject to a fine or a custodial sentence up to 5 years. And we see this typical scenario in the second bullet. There are 3 people, A, B, and C. They each dumped household waste in a small lake. In a short period of time, in the order of A, B, and C. And the amount of the individual waste was less than the limit of punishable amount. But the total amount added together hit the requirements of the Article 324 of the German Criminal Code. And there are three possible opinions. The individuals' behaviors and the final outcome when considered, all of the A, B, and C are not punishable for their individual deeds. But there is a second opinion, and this is by many German scholars. Looking at the added, they're just looking at the overall final outcome, the result, and they're saying that all of A and B and C are subject to punishment. And according to Dr. Cullen's cumulative offense theory, you look at the individual deeds, and you don't look at the causality, but without the risk of the criminal punishment, the individuals are liable to repeat their behaviors. And so Professor Zalliger says he's of the third opinion. It's of a differentiating approach. And what that means is only person C is subject to punishment. And so you look at the division of each of the individual's behaviors. Person A is only responsible for some of the final outcome, so not subject to punishment. But as to the subsequent perpetrator B, he did not exceed the limit. But person C exceeded the limit and is thus subject to punishment. But I am in agreement with the second opinion. And I'd like to now discuss what the Japanese scholars are talking about in terms of cumulative offenses. Yes, let me continue. I would like to talk about people who are in favor of and who oppose the cumulative offense theory in Japan. Before Dr. Cullen came up with the cumulative offense theory in 1978, a well-known professor by the name of Ryuichi Hirano talked about the emission of a substance causing a danger only after it has accumulated. It is emitted from another place or externally, and how to deal with cases where danger arises only when the substance competes with other conditions, or when it is not always clear from current scientific knowledge whether the substance is harmful to human health. Professor Hirano did not use the term cumulative offense, but he had already introduced the concept. And Professor Nagai Madoka, as is mentioned in this slide, 2 years ago, proposed these ideas, and these are some of the excerpts. He also discussed cumulative offense, and he is in favor of the cumulative offense theory. Professor Nagai considers the cumulative offense as theoretically important because there is ground for punishing the cumulative offense. I would like to talk about the prevention theory later, and the precautionary principle is in agreement with the preventive principle. And as for the prevention principle, it has to be an irreversible illegal act. And so cumulative offense and the precautionary theory are in agreement, and I think this puts a lot of stress on the precautionary principle, and I give him credit for that. But he considers the cumulative offender as a potential perpetrator whose impact is not really definite. So this is different from Professor Coulon's theory. And now I would like to discuss the scholars who are partially opposed to cumulative offense theory. In taking precautionary measures, as is mentioned in this slide, as for the prevention principle, in Japan, they say that the scientific evidence must be certain. And in comparison, if the scientific evidence is not certain, then they cannot take any legal measures and punishment, and that is the precautionary principle. Professor Nagai linked the cumulative offense to the prevention theory, and that is the prevalent theory by the Japanese scholars. And Professor Yukamon is of that opinion. Just looking at the behavior, actual harm may occur to human existence in the future. So she talks about the illegal waste dumping as an example. To justify the cumulative offense, you have to look at what substantial harm or impact the behavior has on the human health. There must be sound scientific proof. And so to this opinion, climate change is along the same line. Scientifically proving the causes of climate change had taken place. There are other reasons other than carbon emissions. But if the evidence is uncertain, then criminal punishment cannot be used. But if we cannot use such measures, then we are at a loss. And then there are two people who oppose the cumulative offense theory altogether. Professor Sang-gyun Kim of Ryukyu University says the following. Professor Kim says that cumulative offense theory only looks at the final outcome, and it has limitations, and it reduces the liberal security function of the offense, and it only allows excessive intervention by the state in the personal lives of individuals. And Professor Nagai, in response to this, says punishing water pollution is not reducing the liberal security function. As long as the water pollution threshold is set at a legitimate matter, it is not intervening in the personal lives of the individuals excessively. You have a clear guideline and threshold, and you can prevent the next Minamoto scandal that had occurred. And ultimately, you can protect the lives of the people, and that kind of state intervention is legitimate. And next, I'd like to talk about another opponent of cumulative offense theory, who is Yu Wei-shih of National Taiwan University. He is a well-known figure in Japan, and he even wrote his doctorate dissertation in Japan. And Professor Yu Wei-shih says that the concept of cumulative offense violates not only the basic principles of criminal law, but is also excessive social risk management. And it only legitimizes people's concerns about possible risks. And he goes on to say that we have very little idea of what values future generations have, what their interests are, and what their aspirations are. We cannot know at this point in time. And people's values and ways of life are diverse, even if they belong to the same generation. So if we're to talk about the generations after hundreds of thousands of years, it is difficult to predict. So it's impossible to consider environmental ethics that will be common to the later generations. In the end, the view that insists on consideration for the future generation only falls into paternalism. And to this, Professor Nagai criticizes, saying that global warming and climate change are sure risks. And we have partial proof of that. Of course, we cannot have 100% proof that climate change is taking place, but we cannot wait until the Earth collapses, because by then we'll all become extinct. We are faced with the existential threat. Of course, some threats are not visible, some parts are not scientifically proven yet, but better be prepared, as the old saying goes. So there is no harm in being prepared, and that's the safest risk management that we can do. So we cannot blame the risk management for being excessive. And as for calling this paternalistic, we need this because it's an altruistic act and it's not intervening in the other's affairs. It's paternalistic to the extent that we care for the well-being of our colleagues. So the younger generation professors, I don't know about the other countries, but for the preliminary principle and the intervention of criminal law in climate issues, they are against. And as was mentioned, as for the cumulative offense, the younger generation of professors are against. But Professor Nagai and I myself believe that precautionary principle and cumulative offense are valid concepts in dealing with climate change. But interpreting cumulative offense, I have a sort of a different opinion from Professor Nagai. I think it is a far away risk, and as was mentioned before, in dealing with the climate change, the greenhouse gas concentration in the atmosphere is happening, is rising. And it's not that we want to punish a minor act of crime which has abstract consequences. The consequences are concrete. And we need to have a different approach. So as for the causality and as for the attribution, I think we should adopt the cumulative offense theory because it provides us with an effective framework. And as for the precautionary principle, I am in agreement with Professor Nagai's opinion. We should not wait for the certain scientific proof. If we wait too long, then it will be too late. Some people are saying we are already late. And then there's the microplastic issue polluting the oceans, killing the fish and the aquatic life. And of course, we do not have 100% scientific proof of what kind of harm it has on the human health. But we have to find the countermeasures now. Otherwise, it will be too late. So we have to act now and come up with measures to deal with plastic waste. And so I think cumulative offense theory will help in this regard as well. So the precautionary principle and the cumulative offense, these are the frameworks that will help us guide in our legislative efforts. I think they will be very helpful. But in legislation, specifically, how can we categorize the types of crimes and criminal behaviors? That is very difficult. I would like to take this up as another research topic. With that, I'd like to conclude. Thank you.
Yes, thank you very much. Professor Kawaguchi talked about cumulative offense, which is a very interesting topic. And talked about a paradigm shift, breaking away from the traditional legal concept. It was interesting because usually scholars thought that ecosystem needed a transitional concept, which is non-cumulative, and the fact that the tool is cumulative offense is very interesting. That means our everyday actions can suddenly become a criminal offense, and that's kind of scary. Now I'd like to introduce the third presenter, Ms. Magali Bobbio, the legal officer of ICC, is a lawyer, and she majored in law and Buenos Aires University. She also received her master's degree at Amsterdam University, and she was the summa cum laude. She majored in international crime and criminology. She worked for many years in Buenos Aires, provided legal advice to the judges. She is now at ICC and provides legal advice to the 5 judges. She also attended many conferences and can speak Spanish as well as English. She published many papers as well. Please go ahead.
Thank you very much for your very kind presentation. Thank you for the invitation. I'm honored to be here today as part of this panel. And without any more, I will start because I want to stick to the 15-20 minutes. I hope everybody can see the presentation. So thank you very much. And today I would like to discuss something that has already been touched upon by other speakers, and it's the possibility or otherwise of prosecuting environmental crimes as international crimes under the current legal framework. So we have been discussing already the possibility of incorporating a new crime, ecocide, or we can call it otherwise, but crime against the environment as an international crime under the Rome Statute. Currently, that's not there. So my discussion will be on the current legal framework. Would this be possible, yes or no? Before I start, I'm just a disclaimer that I always have to make because I work for the International Criminal Court. However, today I'm going to be expressing my views, which do not necessarily reflect those of the court. And with that disclaimer, I would like to discuss today 2 different set of considerations. The very first one is whether the prosecution of environmental crimes before the International Criminal Court under the current legal framework is possible purely from a legal point of view, so from a legal perspective. And if that is possible or may be possible, would this be pragmatically possible? Is this ever going to happen? And for this, it's of course different considerations, more policy considerations. So let's start with the legal considerations. And I think Professor Sasker already mentioned, the only provision in the Rome Statute that actually mentions crimes against the environment is Article 8.2b4, which I'm going to just read to you. It's the internationally launching an attack in the knowledge that such attack will cause incidental loss of life or injury to civilians or damage to civilian objects, or, and this is the important part, widespread, long-term and severe damage to the natural environment, which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated. This is a war crime. This is a violation of international humanitarian law. But of course, it has several limitations for the prosecution of environmental crimes before the court. Several requirements need to be met, proportionality with the attack, etc. But I think to me, the most important limitation is the fact that this crime needs to be committed in the context of an international armed conflict. As we all know, the most predominant conflicts nowadays are non-international armed conflicts. And there is no equivalent of this provision for non-international armed conflicts. So that's already a very huge limitation, and that might explain also why to this date no crimes have been adjudicated under this provision before the court. Then we move to genocide. Would it be possible to prosecute environmental crimes as acts of genocide? And I think this is even more difficult because of the specific volitional element, the special intent that needs to be fulfilled, that characterizes the crime of genocide. The act, in this case, an environmental crime, would have had to be committed with the intent to destroy in whole or in part a national, ethnic, racial, or religious group as such. This is what Article 6 of the Rome Statute tells us. So this is a very, very huge limitation for this possibility. So what we are left with is crimes against humanity, and I think most of the scholars, most of the academics agree that this may be, although there are, and we're going to discuss now, several counter-arguments, this could be a possibility. So in terms of what are the relevant considerations for the possible prosecution of environmental crimes as crimes against humanity, and I think several of the speakers have already mentioned this, crimes against humanity protect are focused on harm to human beings. They are not focused on harms to environment per se. So the harm is anthropocentric. And the question then is, are the environmental crimes, because of the type of damage that they cause, could they be also considered anthropocentric? And one could argue, maybe, if the environmental crime is viewed as the tool to violate human rights, and in this way cause harm to human beings, then there could be a link between these two, and one could consider in some cases, not all of the cases, in some cases where some conditions are met, environmental crimes can also cause harm to human beings and therefore consider anthropocentric. Then we turn to the most technical and difficult question to me, which is under which specific prohibited act of Article 7.1 would environmental crimes fall under? And here I'm just raising three because these are some of the examples that I have come across when doing some research into this topic. Some argue they could be considered under 7.1K, and this is understood as a residual provision because it refers to other inhuman acts of a similar character to those in Article 7.1. So there need to be two specific conditions for environmental crimes to be prosecuted under this provision. One, they must cause great suffering or serious injury to body or to mental or physical health. This is in Article 7.1K. And the second one is the one I just mentioned. The nature of the crime needs to be similar to the crimes listed under Article 7.1, the other crimes. The second possibility, and this is also a tricky one because some of the challenges relate to the challenge I just mentioned in relation to genocide, is the possibility to prosecute it as an act of extermination under Article 7.1b. This crime is defined as the intentional imposition of living conditions, including the deprivation of access to food or medicine, among others, aimed at causing the destruction of part of a population. So what we see in the definition of this crime is that there is also a requirement of a special volitional intent. There needs to be this intention, this objective of causing the destruction of part of the population. If that is not there, then it's not possible to subsume the conduct under this provision. The third possibility is to consider it as a crime as an act of deportation or forcible transfer of population, meaning the forced displacement of the persons concerned by expulsion or other coercive acts from the area in which they are lawfully present, without grounds permitted under international law. And here, I think something that might be interesting to know is that the first proponent of the wording of this provision, who was a UN Special Rapporteur, actually considered in his analysis the serious and intentional damage to vital human assets such as human environment. So these are some of the possibilities. Maybe later in the discussion we can maybe brainstorm about others, but I think these are the ones that are that tend to be the ones that scholars and academics refer to. The most important aspect, the most important requirement, regardless of which of these prohibited acts we would like to subsume environmental crimes under, is that we always need to establish, and of course some other speakers have already mentioned this because it's one of the most important requirements in criminal law generally, is the causality link between the damage and the human right violation. So in this regard, there will always be a need to assess on a case-by-case basis the proximity between the environmental damage and the human right violation that is caused. And then we move to something that I think Professor Satzer also mentioned already, which is the mental element requirement in Article 30 of the Rome Statute. Article 30 requires that every prohibited act, in this case under Article 7.1, is committed with both intent and knowledge. And some people have understood that Article 30, I think there is unanimity, that Article 30 covers both dolus direct and indirect, so dolus of first degree and second degree. However, there is not consensus, and there are diverse opinions on whether this article also encompasses dolus eventualis. The text of this provision, because I think it's interesting to understand, refers to the person meaning to cause a consequence or is aware that it will occur in the ordinary course of events. So there has been a lot of debate as to what this exactly means. Does this encompass dolus eventualis or not? And this is an important question if we are considering the prosecution of environmental crimes before the International Criminal Court, because as we all know, generally these type of crimes are not committed with the direct intent to cause harm to civilians. This is more something that could be envisaged and the person acts regardless. So whether dolus eventualis is encompassed or not is a very relevant question to this discussion. And then we go to the contextual elements, because as we know, and this is the distinction, of course, with ordinary crimes, if we want to prosecute environmental crimes as crimes against humanity, there are a series of contextual elements that also need to be met. And in a nutshell, the conduct needs to be part of a widespread or systematic attack that is directed at a civilian population and that is carried out pursuant to a state or organizational policy. So in interpreting the meaning of attack, there has been now jurisprudence stating that the acts that form the attack do not necessarily need to involve per se physical violence. And this is something also very relevant. An example that has been given in this regard is the crime of apartheid, which do not necessarily involve, it does involve violation of human rights, but it does not always necessarily involve physical violence. This is again relevant for this discussion. Why? Because environmental crimes, and I think that we have been now discussing this, the causality link and with the damage that is caused to humans, it's very relevant because it does not always involve directly physical violence. So this interpretation of attack is important to the discussion. And then we turn to the meaning of what does it mean that an attack is directed at a civilian population. And there has been a lot of confusion as to how to interpret this. And the appeals chamber has recently clarified the meaning of this. And the meaning is purely to distinguish it from a lawful military attack. So the distinction between an attack that is directed against a civilian population and a lawful military attack is that the attack is carried out in a way that is consciously attacking a civilian population, but the objective of the attack might be different. So if we have a military attack with a military objective that is carried out regardless of whether there are civilians present, the attack is carried out anyway, then there is also a possibility, and there is a lot of jurisprudence on this, that this can be also considered an attack directed against the civilian population, regardless of the military objectives that were pursued by that attack. Again, very important for this discussion because companies or the people that commit this type of criminality, environmental crimes, they are not per se targeting civilian populations. That might not be their primary objective, but that might be definitely collateral damage or whatever way we want to call it. So this is again a very important aspect to highlight. The same for the state organizational policy. There is a lot of jurisprudence from the court now clarifying the policy does not need to be a policy to attack the civilians, but it has to be a policy, the implementation of which is going to result in an attack directed against the civilian population. Another big challenge of the potential prosecution of environmental crimes before the International Criminal Court is that these crimes tend to be committed by legal entities. They tend to be committed by companies that are seeking profit and not by individuals. So one could wonder, well, the ICC has no jurisdiction over legal entities. It only has jurisdiction over individuals. And here, of course, the argument can also be made, yes, but legal entities are actually run by individuals. So you can also prosecute individuals, you can prosecute the CEOs, and in this way aim at having a deterrent effect for others that are thinking of engaging in the same type of conduct. And another important consideration is, what about the penalties? What kind of penalty are we going to impose if we prosecute, if we convict a person, the CEO of a company that engaged in environmental crimes that amount to crime against humanity? Are we going to put that person in prison? Is that actually sufficient to have this deterrent effect or not? And I think here it might be interesting to also consider the possibility of economic sanctions, because that's also envisaged in Article 77 of the Rome Statute. It's possible to impose fines. It's possible to proceed to the forfeiture of the proceeds, property, and assets derived directly or indirectly from the crimes. And perhaps these economic sanctions might be the ones that have the most deterrent effect for this particular type of criminality. So if we assume that in certain cases where all these conditions that we have just been discussing, legal conditions are met, we then go to, okay, but is this actually something that realistically is ever going to happen? And here I would like to highlight, some of you might already be aware, in 2016, the prosecutor of the International Criminal Court, in one of its policy paper, a policy paper on the selection of cases, so a paper where the prosecutor explains its policy on how it's selecting cases for investigation and prosecution, they specifically said, in its consideration of the gravity of the crimes, the prosecutor would take into account crimes committed through or resulting in environmental destruction. And this has not yet happened. However, as also has already been mentioned, there have been several communications from different organs, including NGOs, and I think the most recent one indeed is the one from All Rights in relation to what's happening in the Amazon. There are communications to the prosecutor, so now the ball is with the prosecutor. It remains to be seen what's going to happen. We have now, of course, a new prosecutor. So this is an interesting point to highlight. But we should not forget what the focus of the court is. And the focus of the court, as the preamble clearly states, is on the most serious crimes of concern to the international community as a whole. We also have, in addition to a limited focus of the court, a limited scope, we also have limited resources. The prosecutor has limited resources. So then the obvious question that arises, okay, are then environmental crimes sufficiently grave? Are environmental crimes those crimes of the most serious one of concerns to the international community? And again, personally, being a mother and having children? I think it is, because if we think about it in very simple terms, without environment, there is no humanity. So, of course, we should be careful, and we always need to establish the causality link, but one could make the argument. However, we should not forget, and I think the point has already been made, criminal law is the last resort, and the International Criminal Court is the last resort, because the prosecution of this type of crimes lays primarily with domestic jurisdictions. And the court is only going to intervene in those cases where domestic jurisdiction are either unable or unwilling to carry out those prosecutions. So with all these considerations, I think my conclusion, and I'm very interested to hearing the views of the other members of this panel, would be, I am in favor of the proposals to amend the Rome Statute, because I think that would make the prosecution of these types of crimes more straightforward and require less legal creativity. But in the meantime, of course, these crimes continue to happen. As we all know, an amendment to the Rome Statute is likely to take years. So what are we going to do in the meantime? And I think it's worth exploring these possibilities, even if they only serve to encourage states to pay more attention, to prosecute, to investigate, and to make their domestic system stronger to prevent the further commission of environmental crimes. And with that, I thank you very much, and I'm very happy to answer any questions when we have the discussion.
Bobbio.
Thank you very much, Madam Magali Bobbio. She talked about the Roman statute and talked about the possibility of prosecuting environmental crimes. And following her presentation is the fourth presentation that could be defined as an actual ecocide dealing with humidifier disinfectant. I would like to invite Dr. Yeyong Choi with Asian Citizens Center for Environment and Health. He's a scholar and an activist. Is served as the director of Asian Citizens Center for Environment and Health, and went somewhere else and then joined the center again. He graduated from Seoul National University majoring in industrial engineering, and he got his scholarship and attended the master's degree in University of London, and then he got his PhD for environmental health at the Public Health Graduate School of Seoul National University, and is working to eliminate asbestos and has worked in Korea Federation of Environmental Movement. And he has written many papers and is an activist for solving the humidifier disinfectant issue. And he has written many articles, and he is working hard to include ecocide as one of the international crimes at ICC. With that, I'd like to invite Mr. Choi.
Thank you for introducing me, and I'm happy to have this chance to discuss about this serious issue, humidifier disinfectant, particularly not only some Koreans, but also some foreign speakers, particularly the ICC and some legal person. I'm not a legal person, but it's quite interesting to listen what other guests speak about criminal issue as environmental issues. Okay. Today I'd like to speak about what humidifier disinfectant disaster like these 5, 6 small topics I'd like to introduce to you. And humidifier. Many of you know about what is a humidifier. Humidifier, particularly in Korea, are widely used, especially dry and cold winter season at home and at office, especially homes. Having babies and children who are sick and old age people to prevent cold or ill worse, and recommended by medical doctor try to maintain humidity. Humidifier disinfectant, this is a strange thing. Humidifier has a water tank to supply humidity, right? But because of fungus and alien substance in the water tank, there were caution and warning to clean the water tank frequently, but not easy for the consumers daily. There has been a medical report about humidifier lung, which is a kind of respiratory disease by the contaminated humid by the humidifier.
예, 소장님,
네.
잠깐만
Excuse me, could you share your slides? I did screen share. No, it's not working. I'm sorry, I will try again.
Done?
예, 됐습니다.
Yes, it's working.
Okay, let me continue. Yeah. So in 1994, a huge Korean chemical company, SK Chemical, developed humidifier disinfectant products, which is a liquid type. And they advertise like this: easy and good hygiene, and simply mixing into the water tank, then it is safe, perfect. By 2011, for 18 years, nearly 20 years, you see, at least 48 brands and nearly 10 million products have been sold nationwide in Korea and some other countries like US, China, where lives Korean. This is some samples of sample pictures of the humidifier disinfectant. As you see, British Reckitt Benckiser's products, British Tesco together with Samsung, at the Home Plus, which is a huge a supermarket in Korea, and Irish Medentech, and Danish Catox, and Japanese Daiso. So like this, multinational companies products produce a lot, as well as Korean producers. What is humidifier disinfectant disaster? In 2011 August, after 18 years since the first sale of the product in 1994, Korean government, a Center for Disease Control, released an epidemiology investigation result that humidifier disinfectant could be a cause of pregnant women death cases. In 2012, and next year, February, the toxicity and fatality has been confirmed with animal tests and clinical surveys. 3 years later, in 2014 April, first Korean government official medical approval of the 168 victims, mostly severe respiratory failure cases of the 361 cases, with many deaths, and many of them were infants, children, and pregnant women. By November 2021, quite recently, 7,598 cases registered, together 1,724 death cases, which is nearly 23%, and 4,274 cases, which is 56%, have been approved officially from the relief system, mostly asthma, pneumonia, and interstitial lung disease. And let me show you some victim cases. This baby is survived, but has a lot, quite seriously respiratory disease. And this baby unfortunately died with age 3 after exposed to the British humidified disinfectant. And this is a CT film of a lung with a serious pulmonary fibrosis of 3-year-old girl after humidified disinfectant project. You may have seen, if you have seen before, the CT film of your lung, the normal lung. Yeah, it should be black like this part and this part. But as you see, a lot of white spots, which means fibrosis. And this is another film, a case of acute development of fibrosis within 1 month of a pregnant woman, which is, from here, from the left to the right, within 1 month, dramatically worse. And this baby died of 2 years old. This baby dies of 3 years old. And this mother died of 35 years old. And this baby luckily survived, but with very serious respiratory ill function. And this man survived, but a lot respiratory difficulties even after lung transplantation. This baby died of 2 years old, and this lady, actually mother, luckily survived after a lung transplantation, and she's quite a rare case after lung transplantation and okay till now. And this baby in the middle died of 3 years old, but the left man, the right man is his father was his firefighter, rescuer, but he couldn't save his son. This baby died of 2 years old. His mother died of 35 years old. And this is a quite recent case. Kim Eung-ik, he died quite recently last month after 1 year after lung transplantation. He exposed to the British humidified disinfectants. And in 2015, we visited to protest UK, London, and The Guardian report our activities in front of here, British Parliament House. And this is the report. And let me brief some problems summarized. First one is genocide. Nationwidely, nearly 9 million users, almost 1 of 5 Korean, and nearly 1 million health damage cases, and including more than 20,000 death cases. I have never heard about any, I don't know anything similar case like this, death and health damages since 1950 Korean War. Literally genocide. But only less than 1%, 0.8% so far found and registered. There has no actual trial to find out the victims by government and producer companies for 10 years. Problem second, no safety measures. The right figure shows from 1994 till 2011 how many humidified disinfectant brands comes and make problems. There's no product safety measure by companies and government about this kind of daily products. no safety tests before marketing by none of all 48 brands, mostly large companies, including Korean companies, SK, LG, Samsung, Lotte, GS, Aeon, Shinsegae, E-Mart, etc. And also, many multinational companies have produced these bloody products. Rackets from a former racket banker is a British, Tesco, British, very well-known big supermarket, isn't it? Henkel, German, and Catox, Denmark, and Daiso, Japan. UK-based racket, which is known as Oxy in Korea, sold nearly half of the toxic all humidifier disinfectants on the South Korean market, but could not sell the same products in the UK or Europe due to the law prohibiting use of their toxic ingredients. After harm to Korean consumers become apparent, Racket engaged in scientific flaws by paying 2 Korean university professors to publish papers exonerating their toxic humidifier disinfectant products. Ironically, the company's slogan is protect, heal, and nurture. Problem 3, lack of corporate accountability. So far, this problem divided relief and compensation. You may know the definition of relief and compensation, which is completely different, isn't it? Very limited responsibility by the producer companies. Only 16% of 4,828 approved case has been compensated, very little. And there has been limit of a medical approval system. Only 3 diseases among various symptoms the victim appealed. And very limited legal approval system and a very weak of victim group and civil groups. Lack of corporate accountability. None of the companies producing humidifier disinfectant tested the respiratory safety of these chemicals, despite the fact that they would be used in the humidifier and inhaled by consumers. Mr. Gaurav Jain, a former Racket CEO in South Korea, flied to India to avoid charges as Korean prosecutors revealed that Racket has concealed evidence showing that the company knew that principal active ingredient of its product, PHNG, was very toxic. Mr. Jain is still working for Racket in India and is currently on Interpol Red Notice list appealed by Korean Prosecutor's Office. Here I have, I want to share with you maybe 5 lessons from this disaster. Let me quickly say. And first one is one single consumer goods or daily necessity of home chemical products could kill catastrophic massive consumers, particularly biological vulnerable people, so-called biocide disaster. And similar disaster could be happen any place in any countries globally, as far as increasing consumption of the daily chemical products through global market. And chemicals, products for consumers, no or little harm for skin or eating, but very fatal harm to lung. With the same one, all kind of inhaling types, sprayed type should be safety tested before marketing. And a strong legal obligation for the consumer safety should be legalized as today's main topic. Finally, an international humidifier disinfectant convention should be adopted by United Nations, not to be repeated like Minamata Convention case. And UN Commission on Human Rights, World Health Organization, United Nations Environment Plan, and Asian Environment and Health Centers, this kind of international bodies should lead these activities. Here we have I'm a German speaker and Japanese speaker. Surprisingly or not surprisingly, comparative cases with humidified disinfectant disaster, they're well-known global scale environmental health disasters in terms of scale and severity, such as Minamata disease, thalidomide disease in Japan and other countries, and Bhopal disaster in India, are all ongoing till now, but there has no full-scale investigation of victim finding, no real compensation for the victims, and no actual liability to the relevant companies and government. And now we have humidified disinfectant disaster, radon bad event in Korea, and LG chemical styrene gas leakage, which killed more than 15 Indian residents. Similar disaster happened again and again. Human rights approach to humidified disinfectant disaster like this. And I have no time, so let me quickly skip some parts like this. And this one, criminal case approach to humidified disaster. Humidified disinfectant tragedy is not well known outside of South Korea. However, due to its position as market leader, US-based racket did attract the attention of the US press, as I mentioned. And 2016, South Korean prosecutors brought charges including loss of life against more than 14 racket employees in South Korea, including one of the former CEOs. Additional charges included criminal negligence for failing to inspect the safety of the product and allowing itself, and forced labeling for marketing it as safe. As the legal process, the Supreme Court sentenced them to 2 to 6 years in prison in 2018. As of this date, there are still 2 people in jail, which is far not enough. And however, Mr. Garb Jain once again, the problem. Mr. Jain rebuffed a summons from Korean prosecutors and refused to meet with South Korean government representatives who visited Racket's office in India in 2019, which I lead the representatives. As a result, Mr. Jain has been placed in Interpol Red Notice list. As you may know, what is Interpol Red Notice list? Several hundred high-level and board members of the companies produced humidified disinfectant has been accused by victim and civil groups. However, only dozens has been indicted and only some of them sentenced guilty finally, but many others acquittal and ongoing the trial process. But so far, none of the government officers has been openly investigated and indicted at all. This is my last slide. Global scale health and life damage cases caused by environmental problems such as climate crisis or chemical abuse, in other words, ecocide, particularly vulnerable population, children, pregnant women, sick and old age people are the victims. And particularly related with the multinational companies and agencies, should need survey the full-scale victims, investigation as international crimes, which should jointly be by national government and international agencies like international crime, criminal crime. Thank you very much for your listening.
Yes, thank you. That was Director Yeyong, and he gave a detailed report on the case of the humidifier disinfectant, and said that it could become an example of ecocide from the broader perspective. Now we will have a roundtable discussion. and this includes everyone, but Professor Zatsker had to leave at 6:10 because of other commitments. So we will have the remaining speakers and 2 discussants engage in discussions as well as questions and answers. Also, we have online participants. We will receive their questions or comments online as well. The 2 discussants that we have today is Professor Lee Sun-jun from the Law School of Chungbuk University and Professor Lee Won-sang from the Chosun University Law School. These 2 professors are progressive and quite young, or on the young side, professors. Unlike other legal scholars, they have been interested in very recent issues, including self-driving cars and other very modern issues. So I'd like to ask the first discussant, Professor Lee Sun-jun, to go ahead. Thank you very much. It's good to see you. Although it's a webinar, it's a great pleasure to be able to engage in discussions with recognized scholars and other experts. Korea is also quite active in responding to climate change. Korea used to be reputed as a climate villain, but nowadays Korea is changing its direction to become more sustainable. As the moderator just said, I am very interested in corporate crime. Corporate social responsibility and environmental protection are some of the issues that I'm very interested in. Recently, a new corporate norm called ESG has emerged, and this has made the link between corporates and environment more visible. For example, we have a KEPCO, the Korean Energy Corporation. However, the Netherlands, the Dutch investor sold 60 million won worth of stocks because they found KEPCO to be unsustainable. There are many natural disasters also taking place. For example, in Canada, they believe that they are suffering harm that could affect their economic growth as well. This means that climate change and environmental crime is directly related to humanity. Swiss Re, the reinsurer of Switzerland, says that, of course, it depends on the scenario, but 48 countries will be affected by a rise in temperature. When 2% rises, the economic growth will decrease by 4% and decrease by 80% when there's a rise of 3 degrees Celsius. And due to many climate disasters, about 12 trillion won worth of harm was caused. In Korea, we have a law that governs corporate crime, and the base is permissible level of act, so it's different from precautionary regulation. I believe that in environmental crime, the most important thing is the concept of ecocide and also protecting the interests of the concerned. As you said, life, body, and in terms of economy, we see that harm is being visible. Harm is being quantified. So whether we understand it from the ecosystem's point of view or whether we understand it from the human rights point of view, I believe there will be a lot of progress. Causality in the Constitution, does that have to be revised? I believe that, although we live in the age of science, I believe that all phenomena cannot be proven by science alone. As Director Choi's presentation showed us, the disinfectant is such a case. We believe that natural and scientific causality may exist, but if this is not revealed, we cannot assume it as having no causality, but we should try to revise the idea of causality. And guanide pellet is not adopted in Korea, but in Korea, we have what we call an estimation of causality. I believe that we can make use of this provision, and that will allow us to effectively deal with ecocide. Nevertheless, the case of the disinfectant manufacturer, ABC, is not an easy case. Unlike Europe, Korea is not adjacent to many other countries. We don't have many neighboring countries, but we do share an ocean with our neighbors. So a lot of times, the ocean pollutants are sometimes reach Korea. So this means that this transboundary pollution is very important to Korea. I think that we can first start with domestic law. I'm not that knowledgeable about international crimes, but we can first have the domestic law deal with this and hold the polluters responsible. In this respect, I'd like to ask this question. It's not going to be easy for relevant law to be introduced. So, Ms. Bobbio, I'd like to ask that ICC is working on issuing an order of a conversation or indemnifying such polluting acts. In Korea, there is a provision that limits the employment of environmental criminals. I wonder if this could be a valid solution.
성준 교수님 토론 감사합니다.
Thank you, Professor Lee. There was a question addressed to Ms. Bobbio. We will first listen to the comments from Professor Won-sang Lee and then deal with all the questions. Professor Lee, hello. Thank you for inviting me as one of the panelists. I was listening to the presentations, and so at the end of the day, we all have a similar level of awareness from what country we're from. I think we are pretty much in a similar position. And another thought is I am polluting the environment as I speak. I am breathing carbon dioxide out, so I'm a major pollutant. Can I be free from such a criminal act? When we look at the environmental crimes, and there are many layers, there are crimes that are committed by citizens indirectly without intent. And as it can be seen from the humidifier disinfectant, there are some people with ill intent. But just referring to the former, the general public committing some acts without us knowing, I think that could have a more grave consequence because people consider themselves not guilty. For example, we're living in the COVID-19 pandemic, but if somebody is not dying from the virus, people do not consider this as a serious issue. And as we saw from the comment by the foreign minister at COP26, the island has to sink. The volcano has to explode in front of me. Otherwise, we don't consider the crimes as serious. And so because of that, we don't consider our behavior as a potential crime. I was just joking about my breathing, but we may be committing something that harms the environment without us knowing. So what role should the criminal law play? Of course, it should be used as a last resort. If possible, it should be used as little as possible. But at the pace that we're going now, I think the principle of complementarity is now satisfied? I think it is time that criminal law steps in. And even if it does step in, can it solve environmental issues that we're faced with? That is the bigger question, as was mentioned by Professor Kawaguchi and as was mentioned by Mr. Yeyong Choi. If it's a legal issue, we are stuck in the past paradigm of causality. And, some of the causality may not be proved. Even if criminal law steps in, you only can look at the result. And if there is no resulting harm, then we cannot apply criminal law, and that is the limitation. But the criminal law can only go forward. It cannot go backward. And so there is this abstract potential behavior that can cause risk. Then how can we define the scope of responsibility? I think there are many issues that we need to consider. But once the principle of complementarity is satisfied and criminal law is applied, there are things that criminal law still cannot handle, and we have to solve that blind spot or the gray area. And the current discourse that we have is we still talk about how to punish once the environmental crime is committed. But we could go one step further. For example, the plastic waste. I know people are trying to reduce the plastic waste, but from the design stage, we could move upstream and maybe prevent the manufacture of plastic bottles altogether. If the legal measures are taken at the very upstream, then maybe the criminal law can have an easier time dealing with the crimes at the downstream. There is a campaign now for the manufacturers so the consumers have to divide and recycle the plastic wrappings from the plastic bottles. And the apartment complexes in Seoul are participating in the campaign, but not as actively. They still leave the plastic wrapping on the plastic bottles. I think, that's because there is no restriction. We need to think about the intent of criminal law. It is to protect the human health. I think the scholars need to give more thought whether it is preventive. I think we should. I think it is time that we gave some serious thought to the potential role of criminal law. And I was heartbroken listening to the humidifier disinfectant case once again. So many lives were lost. But still, the criminal law is not answering to these issues. So what can criminal law do? It should step in more actively and not always leave it as the last resort. As a follower, all my comments were taken by the predecessors, and I do not have specific questions to the presenters. So that was all for my comments. Thank you very much.
Thank you very much, Professor Lee. You said you don't have any specific questions, but you said that for the criminal law to kick in, we need to get away from the modern concept and go toward the concept of environmental jurisprudence. There was a question posed to Ms. Bobbio. Would you like me to repeat it? I will try to repeat it. According to Article 75 of Roman State, there can be an order of indemnification to states. Is there a possibility for this to happen? can you order a state to indemnify environmental harm?
The question would be if the court has the power to order a state party to compensate or somehow give relief to a victim of an environmental crime in the territory of that state party. Is that the question? Yes. Well, unfortunately not, because in such a case, the jurisdiction or the competence is with the domestic authorities. We would be at the stage where there would have been an investigation, a prosecution, and a conviction, I assume, because otherwise you would not be able to order a compensation in the context of a criminal case. And in that case, the court would have not adjudicated those crimes. It would have been the national authorities. So if that were the case, I don't think the powers that the court has vis-a-vis the states relate to cooperation. So once an investigation is open, once even the prosecutor is investigating, even when a chamber has not yet been seized with a request to arrest a particular suspect, the cooperation obligations of the states kick in, and states then do have an obligation towards the court to cooperate in the investigation of the alleged crimes that had been committed. But otherwise, unfortunately, that would not be possible. I hope that answers the question.
예, 제가 생각하기에는 충분히 답이 되은 것 같습니다.
Yes, I think that fully answered the question. We are supposed to conclude at 6:40 Korea time, and we have about 5 minutes left. This is being streamed live on YouTube channels. Could we receive some questions online? Conducting such international fora, I think the online viewers are shy and they rarely ask questions. Maybe one of the presenters could wrap this up with a final comment if there are no questions. If it is all right with you, I have a question. I have a question for Ms. Bobbio. When there is punishment by the ICC,
必要だと、インテンションが必要だというふうに言われたと思うんですけども、ただ環境問題とか考えるときにですね、いわゆるその故意犯の処罰だけで十分なのかっていう点についてやっぱり問題が。
Is it enough punishment on the intention? Is there an intent or not? Sometimes you can say it was intentional, but rather than looking at it as a pure fault, it could be a matter of non-interest in the environment. For example, it does not fall under the scope of intent, but the fact that everybody is not interested results in serious consequences. So I believe, with regard to environment, when there is punishment, I believe that it shouldn't be limited to just intentional act. Even the act of non-interest could be somewhere in between intentional and fault or crime. I wonder how others think about this.
If I may, I think that's a very, very on-point question because indeed, and I think it's something that has been discussed today, and I think it merits a more in-depth discussion, not today, of course, but maybe at some other time, because I think the mens rea element of this crime, of environmental crimes, the link with the damage that is caused to humans is a bit more remote than with a murder or with a rape. So, and that's the issue I think that you are also raising, the intent. Generally, companies or individuals would commit these crimes not because they want to damage people, but because primarily they want to obtain economic profit. So the intent would be either indirect or would actually be, and that's what we were discussing under Article 30, dolus eventualis, because for the purposes of the International Criminal Court, the minimum is knowledge and intent. And there is, of course, we're not going to discuss that today, but for superior responsibility, but that's a very different mode of liability in which negligence or recklessness is also considered, but it would not apply for this particular type of criminality. So for this type of criminality, Article 30 would need to be met, and that means intent and knowledge. How we interpret intent in Article 30 when it says that you are aware that the consequence is going to occur in the ordinary course of events. Personally, again, I'm speaking for myself and not on behalf of the court, I would say that includes dolus eventualis, that includes dolus in the third degree, and therefore, I think some of the examples that we have been discussing today, you engage in a conduct that is causing harm to the environment, but you know that by doing that, you are damaging human beings, then I would say there is intent also for the purpose of that damage, of a lesser degree than direct or first degree, but still is there. That's my personal view, but I fully see your point, and I think it's a concern for many.
예, 그 마지막
Thank you very much. The last question coincidentally boils down to the future task of criminal law. We need to move away from the traditional elements of crime, because if we are stuck in that framework, we cannot solve the contemporary issues. We need to come up with new elements of crime to be able to effectively deal with the environmental crimes. Our bodies could be potential polluters. Listening to Professor Won-sang Lee, I am reminded of a poem, Gobi Desert. My life is an environmental issue and my body is an environmental polluter. I think that piece of literature has changed our mindset. And so we need to come up with a new framework dealing with the ecological side of the law. The scholars, the societies have not been able to deal with this issue, but KICJ was one of the pioneers in dealing with this issue at the forum, and I think this was a very timely topic to discuss. And I'd like to now hand it over to Ms. Yoo-jin of KICJ for the final wrap-up. Thank you. Thank you very much
for great presentations and discussion. I believe that today's conversation provides us with an opportunity to reflect upon the role of criminal law in dealing with the urgent issue of climate change. And now it's time to close the 8th KICJ International Forum. Once again, I would like to thank all speakers and all participants, and we look forward to seeing you again at KICJ Forum next year. And thank you. 감사합니다. 마치겠습니다.
Thank you. Thank you, everyone.